2013-0395-CR1K, styled the State of Mississippi versus Brian Clark. Your Honor, in the main term of court, Mr. Clark entered a plea guilty to one count of aggravated assault and domestic violence. The court has had a status hearing last Friday. Mr. Clark is in court today with his attorney, Rod Ray, for sentencing in this case. May I approach?
You may. Mr. Radford, there's a matter you need to bring up.
Yes, Your Honor. Your Honor, please the court. On behalf of my client, I hereby move for you to recuse yourself in this case. Your Honor, I preface that by saying I've never done that, and I never thought I would do that in front of this honorable court because I'm in front of you constantly. Your Honor, I base my motion on the status conference that we were here on last Friday, wherein the court on two separate occasions, unsolicited by either my client or the state, the court asked, I will recuse myself. If either party asked, I will gladly do so. Your Honor, as this court is well aware, every defendant, no matter what he's accused of, charged with, is entitled to an impartial and fair determination of what should happen to him. In my amended motion for recusal, Your Honor, I filed that this case, as has been pointed out in this case, my client entered a plea of guilty, accepting responsibility for the actions in the case on May 16, 2017. As often happens in cases where a person goes to rehab or has some type of counseling, the court agreed to allow sentencing to be put off until August 10, 2017. Prior to that, I met with Ms. Clemens, requested that she agreed to a continuance. She said, I cannot do that unless and until my client, or not my client, but the victim, Hope Clark, agrees to the same. She agreed to that. We submitted to the court an order of continuance which the court signed, setting this matter for November the 13th, 2017. Several weeks after that, I was contacted by the court administrator and asked if I could be in court on September the 1st, 2017 for a hearing in this case. I did not ask for that. I know Ms. Clemens did not ask for that, but I asked her. So the only inference that my client can have is that the firestorm of publicity in this case has generated the need to see what was going on. Your Honor set the hearing. We came in here, and because of this firestorm, I cited my motion, a blog. I think I'm not very technically savvy, but I think it's a blog out of Jackson. Jackson Rambalai has been very involved in this case. Requested that a reporter be allowed to be here and videotaped the entire 38-minute and 37-second hearing last week, at which, at the 20-minute mark and at the 23:31 mark, Your Honor said, once again, unsolicited, I will recuse myself. Your Honor, the reason that is problematic for my client in this case with regard to impartiality is that we did not ask for this hearing. Our position is the hearing was caused by the firestorm of publicity about this case, about why it being put off again, as Mr. Clark's influence caused this court to put it off. We come in here at the court's beckoning. The court relays several cases that he has handled throughout his years on the bench that are similar to my client's case, and then says, as I said, it's 20-minute mark, I will recuse myself gladly, either side asks. Your Honor, as the tape indicates, which I've attached to my motion, at that 20-minute mark, there's this long pause, and you say, as I'm sure you recall vividly, my brother, a lawyer, contacted me and said, I've got a new vehicle and a condominium at the beach out of this case. Who said that? I don't know. I don't think anybody knows. I don't read the blog because I heard it saying bad things about me. And I'm just representing my client. Having said that interjected into this case the perception or the appearance of impropriety or things that should not be involved in a case. As Your Honor said last week, what happens in a case and what you make your decision on is what happens in this courtroom based on what you hear. So, at the 20-minute mark, when you say, I've been accused of getting, not accused, but I have received these items, you go on to say, right after that, about a lady who doesn't practice much criminal law. She asked you to be involved with the non-adjudication of divorce. She said, I can't do that. You're compounding a felony. And once again, you said, any side wants me to recuse myself, I will gladly do so. Your Honor, I contemplated that for days, met with my clients, consulted other attorneys, moved for you to recuse yourself based on your own invitation that I did not request. I did that because I felt that at that point that this case was, quite honestly, a case I never dealt with regard to publicity and outrage of people in the media. And so we find ourselves the day before trial, and another media outlet has the verbatim.
Actually, this is not a trial.
I'm sorry, Your Honor.
It's a sentencing hearing because Mr. Clark pled guilty to that.
And I apologize, I misspoke. Prior to the day before the sentencing hearing, another media outlet verbatim of the hearing, and from my client's perspective, and what can only be inferred from him, from all this, by him, is this, that the media and allegations of wrongdoing caused us to be here September the 1st, caused you to say, in the context of on the statement, that you would recuse yourself, and here we are asking for justice, which my client's been given for years from you. But this is an unusual case. I've never dealt with one like this. And it appears to us that this is media-driven, and we would not be here today. We would be here November the 13th, but for the constant barrage of outrage over this case is being put off. And everybody involved was in agreement with it being put off until he finishes class. All we're asking for is an impartial and fair hearing. Based on the facts of this particular case and none other, I would request that this court, as you asked if we wanted you to do, I would ask that you recuse yourself.
May I respond?
Ms. Clemens, you may.
Thank you, Your Honor. Your Honor, as the court is well aware, matters, any matter regarding a case are governed by rules. Everything we do is governed by rules. There are rules governing when it is appropriate for a judge to recuse themselves. The one thing that Mr. Ray did not mention that I think is incredibly important that occurred after the guilty plea, but before the case was continued again, is the victim's impact statement was filed with the court, in the court file. That is important because the victim's impact statement has very strong language. It asks for a very stiff and lengthy sentence. It asks for the case to be resolved. And that in and of itself does not, the only word I can think of is jive, with a victim agreeing to yet another continuance. So when the victim's impact statement was filed, the court was in a position where it had an agreed continuance by the parties and a victim's impact statement that had not previously been entered into the file. Those created the conflict. I know the court has been contacted, that letters started coming into the court, phone calls were made. However, I also know the court, as it does in any other case, tells people I cannot talk to you about what is going on in this case. You can write a letter or you can testify. Your Honor, when the court called the status conference, the state's understanding was that the court was trying to clarify the contradiction between the agreed continuance and the victim's impact statement. And that at that hearing, when the court offered to recuse itself, the state's understanding was that the unstated sentence was, if you can show me that I am biased toward one side or the other. Do I know you? Do I know the victim? And the answer to those questions was no. The state has gone back and researched and has found no evidence that either side has ever contributed a reportable amount to your campaign. This, again, the state's understanding is your offer of recusal was, I will recuse myself if either side asks. And by asks, we attorneys know that means you show me, according to the rules of recusal, where it is necessary for me to recuse myself. That has not happened. The court does not know either party. Mr. Ray said that the court had been informed that apparently you had a vote in a condominium by your brother. That was an anonymous poster. The state's understanding is that was an anonymous poster. And that poster did not indicate which side would have offered you a vote or a condominium. Mr. Ray just said, who said it, I don't know, and that goes to the crux of the issue. If we don't even know which side is making allegations in, by the way, a blog, there is still no basis for the court to recuse themselves. We don't even know which side is supposed to have conducted itself in an improper manner. And again, if the court recuses themselves every time someone on a blog says that the court is not going to be fair, then that's going to be really easy for every defendant coming before you who doesn't want to be sentenced by you to get you to recuse yourself by posting something anonymously in a media story. Further, this case has been going on for quite some time. The state sees this as another, I know Mr. Ray is doing what his clients request, that's his job. This is another tactic by Mr. Clark and his family to get this delayed yet again.
Thank you, Mr. Clement.
Your Honor, this is my motion, can I respond briefly?
Sure, sure.
Your Honor, please the court. If this case was brought here on September the 1st, 2017, because of a filed victim's impact statement that alerted people there may be a conflict in what was agreed to by the state, by the victim, and the victim's impact, who notified the court that the victim's impact had been filed? I've never known the court to look at it. Like you said last week, you don't look at the victim's impact, we're in here. So that goes, once again, that does not, something created us or caused us to be here last week. As far as who said,
Let me address that.
Yes, Your Honor.
I can assure you it wasn't correct. What happened is people started calling about the sentence, so I pulled the file so that you'll know. Wanted to know where they could send letters. I think you'll see a little bit there's letters. So when I looked at the file, then there was a victim's impact statement, and it was not there in May. So if your concern is that I read, I'll let you know the news outlets that I read. I watch WCBI. I sometimes watch WTVA too. And I take the commercial dispatch. I have a subscription and had a subscription to that for over 21 years. I also have a subscription to the Macon Beacon, which is the newspaper in Macon. I don't read the packet. It's brought up here at the courthouse sometimes, but I don't have a subscription for that. My online viewing oftentimes is in pursuit of my new hobby, which is guitars. So I spend a decent amount of time on Craigslist looking for used guitars. But otherwise, I'm not a big blog report. I read the Drudge Report, and I read the Daily Beast, to national. Where I tend to read my news, but as far as in-state stuff, not so much. But go ahead.
well, the point I'm making, Your Honor, something caused us to change course in the middle of this trial, whether it be phone calls, some type of pressure on this court caused us to reconvene, which my client believes does not allow him to have an impartial hearing in this case. Whether it's phone calls, we got letters coming, it stopped. And I've never had that before since I've been here. I maybe have missed it, but I've never had a case that was set for, and we continued, we agreed, and all of a sudden people start calling, well, let's come in here and hear about it. That's the perception that my client has, that there's pressure being placed on this court, and as a result, I cannot get an impartial hearing. Therein lies the issue in this case for him. And it is not, no one wants this case over with more than our side. I can assure you, this is not a delaying tactic, because I believe whatever happened today, I know this court well enough, if you did recuse yourself, I'm sure that it would not be a good thing for my client as far as where he would be if you recuse yourself. Because I know that you don't play with continuances or anything else that may not look good with the court. So we're not trying to put it off. We simply want what this court has always provided, and that's a fair hearing. The facts in this case are different than any case I've ever dealt with you or any other judge. Thank you, Your Honor.
Thank you. Thank you. And I appreciate what both sides have pointed out to the board. A number of years ago, I had a case in Starkville where I got a letter on Supreme Court letterhead from a justice on behalf of another justice's son who was in front of me for selling drugs. Both those justices reviewed my work, and there was a suggestion that I recuse myself. I didn't know really either of the justices ever socially other than knowing they were on the court. One of them came on the court after I was the circuit judge. And so there was a suggestion that I recuse myself because here's this son of this justice that I'm going to have to preside over his trial. I thought about that and I thought, well, the problem there is you get a circuit judge to do it, which judge has not got his work judged by those two justices, what we all do. So I stayed, I did the case, and I looked at what I've done in similar such cases. Last week, when I had this hearing, the court's concern was not about publicity. The court's concern was both of y'all had told me that this thing was okay to continue, that you had gotten all the parties' permission to continue it. And I told them, I think I said it before, that I trusted you two with my life. I think if you go back and look at that tape, I think that's exactly what I said. I've had 21 years of dealing with you, Mr. Ray, as an attorney. I was an attorney. Ms. Clemens, it's not been quite 21 years, but
Almost 11.
11, and then knew your father before I knew you as an attorney. So the court was getting lots of calls at this office about where to send letters, and y'all can look, there's a lot of letters in here for both sides. Looked at the file, and then now there was a victim's impact statement in the file. And that victim's impact statement seemed to indicate that the victim in this case was not okay with the thing being continued. So we had a hearing last week. I had the victim brought into court, and we asked about it. So it's not that I thought that you two were being dishonest with me. I didn't think that at all. And as I explained, I think in great detail last Friday, because I think I went through a number of domestic violence cases that I've dealt with over the years. Everything from the guy who shot his ex-wife down at Brooks Park and let her apply for collegiate, and she wanted him to get the max, to a victim's impact statement that I read on a case that's not been trial or plea, where she indicated that what her husband did to her, I think that's her boyfriend, had done to her was terrible. She thought she was going to die. She was worried about her kids. And then on April the 6th of this year, she came into court and sat right there and said, I don't want anything to happen to her. So the point that the court was making, not to y'all, because y'all know this because you deal with it, but to the folks in the audience is, these are not cookie cutter cases. They're not all the same. Not every victim wants the same thing. And they're very complex. And the court tries to listen to what the victim wants. Because once the defendant's pled guilty, the court's emphasis or the concern shifts a little bit more to what do you do to make the victim whole. Sometimes you can't. We had a case here, of course, we all have war stories, but I had a case here, and I think I did it in this courtroom where this young lady had given a guy a ride from Birmingham over here. She knew him to be from Columbus, but she didn't know him very well. And he, once they got to Lyons County, he raped her. In her car, he raped her. He ended up pleading guilty. Her victim's impact statement indicated that she wanted him castrated. And of course, for the witness stand, I told her, the court can't do what you want. Okay, so I've always tried to listen to the victims, but also be fair. I think I may give up a little secret of judging. Every open plea causes the court some concern. Because you want to be fair. You want to be fair to the defendant, and you want to be fair to the victim in the case. So there's always that thought process where you're thinking, I don't want to be so harsh that I'm not being fair to the defendant, but I also don't want to be so lenient that I'm not being fair to the victim in the case. And that's, I'm sure I'm probably not the only judge that engages in that thought process. So when I have an open plea, and I get them fairly often, I take them serious and I weigh them very carefully. When I invited last Friday for y'all to ask me to recuse myself, it was whether I knew either of the parties, and I don't think I've ever run in the social circles that Dr. Clark or Mr. Clark did. So I don't know them. And I got that response from both of them Friday. Did bring up about my brother saying that somehow out of this I got a new car and a condo. The point was, is there anybody that's made donations to my campaign? And that I don't know. When I tell you about the chambers, there are some people that give me money that I know. I ran for the Supreme Court last year. My mother gave me some money for my campaign. I know that. And my brother was an engineer up in at Tupelo at the Toyota plant. I know gave me some money. And I have a friend here in Columbus who's like another mom to me who gave me some money. But other than that, I don't know who gives me money. I follow those rules and trusted that y'all would look and see, and apparently you have. And that no one, either Dr. Clark or Mr. Clark, has given money to my campaign. I think y'all are aware that you can ask a judge to recuse himself or herself if one of the parties to litigation has made a donation to their campaign of a certain amount of money. So there was none of that apparently. The rules don't allow the judges just to recuse themselves from the case because it's going to be tough. If that was the case, there's certainly a number of them that in retrospect it would have been nice to be able to recuse myself and avoid the fallout that's coming with the cases. There was a case that I think you were involved in, kind of on the tail end of it, Mr. Ray, involving a judge from Alabama who got in trouble over here for buying precursors to make methamphetamine. There was a local paper that at the time was owned by someone else, and that owner at that time opined that that judge wouldn't get any time, or that he wouldn't get enough time. I looked at what I had done in similar cases for all involved who'd been charged with a similar such crime. And at that time, that was a 25% crime. I listened to his aggravation and mitigation as we had a hearing on it. A lot of lawyers testified for him and wrote letters. Lawyers that I liked that routinely practiced before me. And at the end of the day, I sentenced him to pretty much what I did anybody who had committed that crime, who was a first-time offender. There were some who were, in that paper, thought that I should have given him more time because he was a judge. Well, I didn't think that was fair either. So I gave him what I thought was right. 15 years of doing this job, almost 15 years, I've been able to sleep with what I do. Because at the end of the day, what the TV says or what the newspapers say or blogs, that's not going to keep me from living within myself and being able to do this job. If I think I've done something for the wrong reason, that's what bothers me more than anything. You can't appeal a guilty plea, but you can appeal a sentence. That's the Supreme Court's made that available. And there's certainly no indication that when I took his plea on May the 16th, 2017, that I should have recused myself. And when I continued that case for August 10th that day, I trusted that y'all had conferred with your clients about continuing. And by the way, I also trusted when I continued it on August the 9th that you both had also conferred with your clients at that time. As I said, what changed was the number of people calling and wanting to know where to send a letter to the file. And as Ms. Clemens noted, that's not uncommon for people to contact the court wanting to know, actually, quite frankly, usually wanting to tell me something about a case and what my staff does. And if I'm the one that answers the phone, I tell them also, write it down, put it in a letter, and send it to the courthouse. And that's apparently what's happening here. Quite a few letters for both sides in the file. The problems that are attended with this case will be attended with this case no matter who the sentencing judge is. One of the oaths that we take, one of the parts of the oath that we take when we're sworn in as a judge is that we won't let somebody's money or lack of money determine justice. And I take that part real serious. My great-grandfather lived out on Anderson Road. He was a coal miner. My grandfather was a paratrooper during World War II, and then he was a carpenter here. My dad was the first sergeant in the Army. And I worked at Walmart, Gray's, and I worked offshore on an oil rig. So never let somebody's station in life influence my sentence. I guess the best thing to know about me is I'm a Christian and an imperfect one. And I know that one day I will face the perfect judge. I'll have to answer for everything I've done while I've been a judge to him. I've been wrong before. I hope I live long enough to be wrong again. But I'm not wrong for the wrong reasons. Because I'm on one side of the middle, one side of the blue. I appreciate your well thought out motion for me to recuse myself. And I appreciate the professionalism that you exhibited in bringing to the court's attention, both sides. But I find the motion is not well taken. I don't know either party. Apparently neither party has given me money to my campaign when I run for the Supreme Court or, in 2014 I didn't even have an opponent, so I didn't collect money. So best that we proceed at this point in time. Do you have any matters in aggravation you wish to discuss?
Yes, Your Honor.